Hello, everybody. Welcome back to Patriot's History of the United States. I'm Larry Schweikart, co-author with Michael Allen of this great book, Patriot's History of the United States, in its 40th printing, 5th edition. I'm working on one final 20th anniversary edition that will be made free right here on the Wild World of History website later this summer. Almost done. Just finished the COVID, or as I call it, the China virus segment this week. So I will be getting that out. So as always, I'm reading through Patriot's History. We are using the 15th anniversary edition. You can usually find where we are by the header. If you have an older edition, that's okay. We didn't change too many of the headers, but today, because we talked about the Northwest Ordinance in some of our last discussions, and I didn't read the Northwest Ordinance. I'm going to read through that for you today and comment on it. So for that, I am using Patriot's History Reader by Dave Doherty, Mike Allen, and myself. And I am reading from the Northwest Ordinance on page 49. Passed by Congress in 1787, the Ordinance for the Government of the Territory of the United States northwest of the River Ohio, commonly called the Northwest Ordinance, was written primarily by Nathan Dane and Rufus King, both representatives to the Second Continental Congress from Massachusetts. However, it was totally influenced by Thomas Jefferson. Both the Land Ordinance and the Northwest Ordinance are Jefferson's ideas. First and foremost, that the land that belonged to the United States did not belong to the United States government. It belonged to people, and that the government should sell it off as quickly as possible in order to get it in the hands of the people. And secondly, that the people who settled in these regions needed to be treated like equals, and they had to find a way, Jefferson believed, to make these people citizens and do so quickly so that they didn't become their own rebels and break off from the United States. Talk about foresight. This was amazing that someone would see. I mean, think about the Romans, right? The Romans never had a clue as to what to do with the people they conquered. Most of them they treated like slaves, like dirt, like conquered people. The Germans, they couldn't make up their mind whether to let them in and make them citizens or try to keep them out, and that basically cost them the whole empire. But here Jefferson said, no, we've got to make sure people coming into this United States are free and equal and have an equal vote and an equal voice in government. In 1784, Virginia had ceded to Congress its claim to lands west of Pennsylvania, north of the Ohio River, with the settlers flooding into the territory. Congress was obligated to take action concerning its government. The result was the Northwest Ordinance, which organized the western lands along the lines laid down by Thomas Jefferson in his Report of Government for Western Lands in 1784. The struggling United States thereby announced to the world that it would expand across the Alleghenies, open up the land for settlement, and create new states. And I should add, have a funding source, because it was selling this land off cheap, but it was getting revenue for this land. So that meant we didn't have to have other kinds of taxes. Not the least of the ordinance's important features was its provision for the advancement of education in the new lands, the exclusion of slavery north of the Ohio River, and its inclusion of civil liberties. Without the Northwest Ordinance, slavery certainly would have entered Indiana, Illinois, and perhaps before long, other northern tier Midwestern states, forever shifting the sectional balance in favor of the South and slavery. Moreover, the experience of American colonists in dealing with England led them to appreciate the necessity for the full political equality of those who moved to new areas. The ordinance applied to the area of Ohio, Indiana, Illinois, Michigan, and Wisconsin, and set the pattern for all other expansion through the creation of the territories that would become states after a required population level was reached. Ohio was the first such territory to become a state in 1803. Although not in the Northwest Territory, Kentucky was separated from Virginia in 1782 with Virginia's consent and became a state following the principles in the ordinance. The office of the ordinance was to end squabbling among states over territory and reduce them to permanent parts of the whole, even before the Constitution was passed. A de facto recognition of the need for a federal government was present, even if it didn't exist at the time. All right, an ordinance for the government of the territory of the United States northwest of the River Ohio. Be it ordained by the United States in Congress assembled that said territory for the purposes of temporary government be one district, subject, however, to be divided into two districts as future circumstances may, in the opinion of Congress, make it expedient. Be it ordained by the authority aforesaid that the estates, both of resident and non-resident proprietors of said territory, dying in estate, shall descend to and be distributed among their children and the descendants of a deceased child in equal parts, the descendants of a deceased child or grandchild to take the share of their deceased parent in equal parts among them. This is what is called partable inheritance, which the North had, but the South didn't. Partable inheritance was you take a square of land, let's say 200 acres. And when Farmer Jones dies, let's say he has two sons, each son gets 100 acres. Let's say each of those sons has two sons and they each die, each of those sons would get 50 acres. It was thought 50 acres was the smallest amount of land a person could own and still be self-sufficient. So usually after a family broke up its land down to the point that kids were only getting 50 acres, they moved west, okay? However, very important that because of partable inheritance, the North broke its farms up into smaller farms consistently over the next 100 years, while the South had primogeniture, which is to say that the oldest inherits all the land and therefore keeps the plantation really, really big. This is one of the three main reasons the South has slavery and the North does not. Partable inheritance and cash crops. The South was growing crops to sell rather than crops they could eat. And the third was because they had cash crops on a lot of land, they needed cheap labor in the form of slaves. Okay. That's what that descendants part is all about. Let's see. And there shall be in no case a distinction between kindred of the whole or half-blood, saving in all cases to the widow of the intestate her third part of the real estate for life and 1/3 of the part of the personal estate. And this law relative to descendants and dower shall remain in full force until altered by the legislature of the district, and until the governor of judges shall adopt laws as hereinafter mentioned. Estates in the said territory may be devised or bequeathed by wills in writing, signed and sealed to him or her in whom the estate may be, being of full age, and attested to by 3 witnesses. Okay, I'm going to have to stop there. It's a really long sentence, but we need to break a lot of this up. First, widows in America were entitled to 1/3 of their husband's lands, no matter what. You couldn't just will all the land to the next male heir. The widow got at least 1/3. Now she could inherit it all if the husband said so in his estate, but she had to at least get 1/3. And you're going, well, Schweikart, that's terrible. Oh, no, 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 no. I say nay, nay. That was far reaching because no other nation in the world had those kind of laws giving women such authority over land. Now, the second thing you'll notice is that it's making no distinction between blood, half blood, pure blood, all that stuff went out with the revolution. We aren't dealing with who's the nephew of King so-and-so, or who's the great uncle of the Duke, or who's the cousin of the Earl, or who's the Duke of Earl. Duke of Earl, or anyway. They're not dealing with that. Okay. People are equal. People are people, no matter where you go, right? How that song goes. All right. Last thing. 3 witnesses. Did you catch that? The Bible says, in the mouths of 2 or 3 witnesses, let every law be established. We took the Northwest Ordinance, this part, straight out of the Bible. Oh, and 4th, written titles and deeds. Did you notice that? The district may change this, but everything depends on those written titles and deeds. Where did you hear that? That's one of our 4 pillars of American exceptionalism. Okay, let's continue on if I can figure out where we picked up. And such conveyances be acknowledged or the execution thereof duly proved and be recorded within 1 year after proper magistrates, courts, and registers shall be appointed for that purpose, and personal property may be transferred by delivery, saving, however, to the French and Canadian inhabitants. You can't give it to a foreign power or other settlers of the Cascaquis, St. Vincent, and neighboring villages who heretofore profess themselves citizens of Virginia. Their laws and customs now in force among them, these would be Indians, relative to the descent and conveyance of property. So once again, it's all legal. It's all done by deeds. Within you have 1 year to get these deeds certified, stamped by the government. Okay, that's plenty of time to get your deed settled. Be it ordained by this authority aforesaid that there shall be appointed from time to time by Congress a governor, whose commission shall continue in force for the term of 3 years unless sooner revoked by Congress, and shall reside in the district and have a freehold estate therein in 1,000 acres of land while in the exercise of his office, while only in the exercise of his office. In other words, a governor doesn't have to worry about making a living while he's governor because he has 1,000 acres that they are going to give him just while he is governor. There shall be appointed from time to time by Congress a secretary whose commission shall continue in force for 4 years unless sooner revoked. He shall reside in the district and have a freehold estate therein in 500 acres of land upon the exercise of his office. It shall be his duty to keep and preserve the acts and laws passed by the legislature and the public records of that district and the proceedings of the governor in his executive department, and transmit authentic copies of such acts and proceedings every 6 months to the Secretary of Congress. There shall also be appointed a court to consist of 3 judges, any 2 of whom to form a court, who shall have been common law jurisdiction and reside in the district, and have each therein a freehold estate in 500 acres of land while in the exercise of their offices, and their commission shall continue in force during good behavior. So Congress says this new area we're creating, it's going to have governor. It's going to have a secretary to take care of all the paperwork. It's going to have a territorial legislature, and it's going to have a court consisting of 3 judges. My reading of this implies that those judges have to have 500 acres before they become judges. You may disagree, but that's how I read that. The governor and judges, or a majority of them, shall adopt and publish the district such laws of the original states, criminal and civil, as may be necessary to best suited to the circumstances of the district, and report them to Congress from time to time, which laws shall be in force in the district until the organization of the General Assembly therein, unless disapproved by Congress, but afterwards the legislature shall have authority to alter them as they shall see fit. So the judges and the governor have to put out the laws of the United States from the Articles of Confederation that they think relevant to the territories, and then they send back to Congress what they are calling their Constitution, and Congress has to approve of that or can change it, or the territory, upon becoming a state, can change it through a constitutional amendment. Previous to the organization, the governor, for a time being, shall be commander-in-chief of the militia, appoint and commission all officers in the same below the rank of general officers, and all general officers shall be appointed and commissioned by Congress. Previous to the organization of the General Assembly, the governor shall appoint such magistrates and other civil officers in each county or township as he shall find necessary for the preservation of the peace and good order. So the governor gets to appoint sheriffs and constables and whatever else to keep the peace. After the General Assembly shall be organized, the powers and duties of the magistrates and other civil officers shall be regulated and defined by the said assembly, but all magistrates and other civil officers not herein otherwise directed shall during the continuance of this temporary government be appointed by the governor. So the governor has a lot of power. For the prevention of crimes and injuries, the laws to be adopted or made shall have the force in all parts of the district, and for the execution of process, criminal and civil, the governor shall make proper divisions thereof, and he shall proceed from time to time as circumstances may require to lay out the parts of the district in which Indian titles, shall be extinguished into counties and townships, subject, however, to such alterations as may thereafter be made by the legislature. So they're saying to a degree, the governors have authority over Indian land. So soon there shall be 5,000 free male inhabitants of full age in the district. Upon giving proof thereof to the governor, they shall receive authority with time and place to elect a representative from their counties, townships, to represent them in General Assembly, provided that for every 500 free male inhabitants, there shall be one representative, and so on progressively. With the number of free male inhabitants shall the right of representation increase until the number of representatives shall amount to 25, and after which the number and proportion of representatives shall be regulated by the legislature. So you can have a big territory that has up to 25 representatives or congressmen, as it were, and after that, Congress can decide to let you have more. The state legislature can decide to let you have more, provided that no person be eligible or qualified to act as a representative unless he shall have been a citizen of one of the United States 3 years and shall be a resident in the district, or unless he shall have resided in the district 3 years, and in either case shall likewise hold in his own right in fee simple 200 acres of land within the same, provided also that a freehold in 50 acres of land in the district, having been a citizen of one of the states and being a resident in the district, or the like freehold of 2 years resident in the district, shall be necessary to qualify a man as an elector or representative. So you had to be either in the district or in the United States for 3 years, and you had to be residing in the district, and you had to have some land. As I said many times before, the founders did not want losers running things. And they figured if you couldn't own a little bit of land, you were a loser. So you needed to have some land in order to be a member of the territorial legislature. The representatives thus elected shall serve a term of 2 years, and in the case of death of a representative or removal from office, the governor shall issue a writ to the county or township from which he was a member to elect another in his stead to serve for the residue of his term. The General Assembly or legislature shall consist of the governor, legislative council, House of Representatives. The legislative council shall consist of 5 members to continue in office 5 years, unless sooner removed by Congress, any 3 of whom to be a quorum, and the members of the council shall be nominated and appointed in the following manner, to wit: as soon as representatives shall be elected, the governor shall appoint a time and place for them to meet together, and when met, they shall nominate 10 persons, residents in the district, and each possessed of a freehold and 500 acres of land, and return their names to Congress, 5 of whom Congress shall appoint and commission to serve as aforesaid. And whenever a vacancy shall appear in the council by death or removal from office, the House of Representatives shall nominate 2 persons qualified and aforesaid for each vacancy, and return their names to Congress, 1 of whom Congress shall appoint and commission for the residue of the term. And every 5 years, 4 months at least before the expiration of the time of service, the members of the council, the said house shall nominate 10 persons qualified as aforesaid and return their names to Congress, 5 of whom Congress shall appoint and commission to serve as members of the council 5 years, unless sooner removed. And the governor, legislative council, and House of Representatives shall have authority to make laws in all cases for the good government of the district, not repugnant to the principles and articles of this ordinance established and declared, and all bills having passed by majority in the House and by a majority in the council shall be referred to the governor for his assent, but no bill or legislative act whatever shall be of any force without his assent. So again, the governor has to sign any bills coming out of the legislature. Governor shall have the power to convene, prolong, and dissolve the General Assembly when, in his opinion, it shall be expedient. The governor, judges, legislative council, secretary, and other such officials as Congress shall appoint to the district shall take an oath or affirmation of fidelity to the office and the governor before the president of Congress and all other officers before the governor. As soon as the legislature shall be formed in the district, the council and house assembled in one room shall have authority by joint ballot to elect a delegate to Congress, who shall have a seat in Congress with a right of debating but not voting during his temporary government. All right, so a couple of important things here. Everybody who's appointed to serve in this territorial government needs to take an oath of office. And they must pledge to be faithful to the Constitution of the day, the Articles of Confederation. Note who they are not being faithful to: the governor. And so when we jump ahead, I just want you to mull this over, okay? Because in Romans, Paul talks about you're to be subservient to all authority. Well, rulers are given to us for our own good. Paul was writing in a time where there was no such thing as a republic, where there was no such thing as a democracy. And as we will see with the Constitution, there is no higher law than God to our Constitution. The president is not who we answer to. We answer to the Constitution. And it's right there when they take the oath of office, because even the president promises to protect and preserve the Constitution, not the office of the president, the Constitution of the United States, to who? All enemies, foreign and domestic. Who could that domestic enemy include? Could include the president, could include Congress. They're not above being enemies of the Constitution. And so I want to submit for your consideration that when Paul was writing Romans, he had no concept of a republic. And in a republic, the man, the emperor, the king is not the ruler. The Constitution is the ruler. And I would paraphrase Paul to say, the Constitution is given to us for our own good, and we are to obey the Constitution, not the man. Because see, it's only in this way can you answer the question, well, what about Hitler? Are you supposed to go along and follow Hitler? Of course not. But see, the Germans didn't have a constitution because Hitler did away with it. So in democratic republics and democratic societies, we usually have constitutions that transcend the man. And populations, in theory, doesn't always work out this way, but in theory, you do not owe your allegiance or your fidelity or your obedience to any man. You owe it to the Constitution, and therefore to the man insofar as he is following that Constitution. That's my sermon for the day. Take it for what it's worth, but that's how I interpret that, and that is laid down right here with the Northwest Ordinance. Now, notice also that the the representative to Congress does not get a vote. While you're a territory, as is Puerto Rico right now, they have a delegate in the U.S. House of Representatives, but that delegate doesn't get to vote. Okay. And for extending the fundamental principles of civil and religious liberty, which forms the basis whereon these republics, their laws and constitutions are erected, to fix and establish those principles as the basis of all laws, constitutions, and governments, which forever hereafter shall be formed in said territory, to provide for the establishment of the states and permanent government therein, and for the admission to a share in the federal councils on equal footing with the original states at as early periods as may be consistent with the general interest. So in other words, they say it again right here. It's consistent only as long as you are extending the fundamental principles of civil and religious liberty that form the basis of these republics. Okay. What did Jefferson say? That all men have the right to life, liberty, and pursuit of happiness, and that they are to support government as long as it is consistent with protecting the right to life, liberty, and pursuit of happiness. And they are to get rid of it when it is no longer consistent with protecting the right to life, liberty, pursuit of happiness. Why? That was Jefferson's early version of the Constitution, the right to life, liberty, pursuit of happiness. That would all be fleshed out in this document we call the Constitution. Okay. But again, I would argue that your allegiance is not to a president, it's not to a Congress, not to a Senate, not to a Supreme Court. Your allegiance is to the Constitution of the United States, and you are to stand with it as long as it is right, and you are to not go along with it if they make you get certain medications. I'll just leave it at that. Article 1. Following articles shall be considered as articles of compact between the original states and the people and states in the said territory, and forever remain unalterable unless by common consent. To wit, Article 1, no person demeaning himself in a peaceful and orderly manner shall ever be molested on account of his mode of worship or religious sentiments in said territory. They cannot take away your religious freedom. Article 2, inhabitants of said territory shall always be entitled to the benefits of the writ of habeas corpus and of trial by jury, of a proportional representation of the people in the legislature, and of judicial proceedings according to the courts of common law. This all has to proceed from common law that the people know best, not the leaders. All persons shall be bailable, that is, you get out on bail, unless for capital offenses, where the proof shall be evident on the presumption great. All fines shall be moderate, no cruel or unusual punishments shall be inflicted. Are you seeing how much of this works its way into the U.S. Constitution? No man shall be deprived of his liberty or property, but by the judgment of his peers, or the law of the land, and should be public exigencies to make it necessary for the common preservation to take any person's property or to demand his particular services, full compensation shall be made for the same. They can't take your land or force you into service without just compensation. And in the just preservation of rights and property, it is understood and declared that no law to ever be made or have force in the said territory that shall in any manner whatever interfere with or affect private contracts or engagements bona fide without fraud previously formed. In other words, contracts are sacred. Article 3, religion, morality, and knowledge being necessary to good government and the happiness of mankind, schools and the means of education shall be forever encouraged. So they supported public schools. Now, the reason then they supported public schools is they knew public schools were going to support the Constitution. They weren't going to allow the stuff that goes on today, ESG and DEI and all this other garbage. They weren't going to permit that. The utmost good faith shall always be observed toward the Indians. Their lands and property shall never be taken from them without their consent, and in their property rights and liberty they shall never be invaded or disturbed unless in just and lawful wars authorized by Congress. But laws founded in justice and humanity shall from time to time be made for preventing wrongs being done to them and for preserving peace and friendship with them. Folks, find me one other nation in human history that after it conquered people made all sorts of laws. England did much later, but we were doing this in 1787, making laws to protect indigenous peoples. Don't let them give you a bunch of Ben and Jerry's garbage. Article 4, said territory in the states may be formed therein shall forever remain a part of this Confederacy of the United States of America, subject to the Articles of Confederation, and to such alterations therein as shall be constitutionally made, and to all acts and ordinances of the United States in Congress assembled, conformable thereto. Now, did you notice something? It did not permit secession by any of these states. If secession were to be something that were to be done, it would have been provided for in the Northwest Ordinance, the earliest constitution we have, but it wasn't. The inhabitants and settlers said territory shall be subject to pay a part of the federal debts contracted or to be contracted, and a proportional part of the expenses of government to be apportioned on them by Congress according to the same common rule and measure by which appointments thereof shall be made on other states, and taxes for paying their proportion shall be laid and levied by the authority and direction of the legislatures of the districts or new states, as in the original states within the time agreed upon by the United States and Congress assembled. In other words, bad news is you're going to pay taxes. The good news is you're not going to pay any more taxes than any of the established states pay, and you're going to vote your own taxes and the way they are to be adjudicated in your own territories or states. Pretty remarkable. The legislatures of those districts or new states shall never interfere with the primary disposal of the soil by the United States in Congress assembled, nor with any regulations Congress may find necessary for securing the title in such soil to bona fide purchasers. No tax shall be imposed on lands the property of the United States, so the territory cannot tax land that is owned by the United States, like a fort or an arsenal, which will later come up in a very important Supreme Court case, McCulloch v. Maryland, where the court again rules, no, the state may not tax the feds. Legislatures of those districts or new states shall never interfere with the primary disposal of the soil. I read that. Let's see. No tax shall be imposed on lands, the property of which the United States, and in no case shall non-resident proprietors be taxed higher than residents. You can't tax people just because they move in from Kentucky. The navigable waters leading into the Mississippi and St. Lawrence and the carrying places between the same shall be common highways and forever free, as well as to the inhabitants of said territory, to the citizens of the United States, and those of any other states that may be admitted into the Confederacy without any tax, impost, or duty. In other words, free trade up and down the Mississippi and St. Lawrence. Article 5, there shall be formed in said territory not less, watch this, there shall be formed in said territory not less than 3, nor more than 5 states. When was this written? 1787. Did we have the Constitution yet? No, we did not. Did we have a Senate and a House of Representatives yet? No, we did not. How genius were these guys? How incredibly brilliant. We didn't have a Senate. We didn't have a House. Yet intuitively, something about them, I think, spoke to their spirits and said, okay, listen up, dudes. Michigan, Ohio, Indiana, Wisconsin, Illinois. Those 5 states, let's call them, if they're one state, Michiana-Ganoy, how many senators would they have had after the Constitution? Well, 2, right? But all those states put together, do you know how many electoral votes they have today? I haven't counted that up. I think Illinois has 27, Ohio has 18, Michigan 22 or something, Wisconsin 10, Indiana 11, 21, 48, 60, 78. If I'm right, it could be off 1 or 2. This Michigan, Ohio, again, whatever you want to call it, would have 2 senators, but 78 congressmen today. You realize what would happen? This one state, Michigan, whatever you want to call it, would dominate the U.S. Congress. It would have more representatives than Texas and Georgia and Arizona put together, or more than California and Kansas and Mississippi and Nebraska put together. It'd be massive. It would totally control the House of Representatives, but said no fewer than 3. What if they hadn't said that and it was broken up into 50 Rhode Islands? How many representatives would each little Illinoisan have? 1. But how many senators would each of these little Rhode Island-sized states have? 2. So they would be small impact in the House of Representatives, but this region would totally dominate the Senate because it would have 100 senators really from the same similar region. Now, once in a while, these states vote differently. For a long time, Wisconsin, Michigan, Pennsylvania voted Democrat, and Ohio, Indiana, Iowa voted Republican, Illinois voted Democrat. So they split. But can you imagine that one area having 100 senators? That's insane. They totally dominate the Senate. They would offset, as of today, all the other states put together. So I go back to ask you, how smart were these guys, not knowing there would be a Senate, not knowing there would be a House, but something inside them says, I think we better break this up into no more than 5, but no fewer than 3 states. That way we don't get a giant state, and that way we don't get a whole bunch of little Vermonts. Amazing, right? And the boundaries of the states, as soon as Virginia shall alter her act of cession and consent to the same, shall become fixed and established as follows, to wit: the western state and the said territory shall be bounded by the Mississippi, the Ohio, and the Wabash rivers, a direct line from the Wabash and the Post Vincents due north to the territorial line between U.S. and Canada, and by said territorial line to the Lake of the Woods and Mississippi. Middle state shall be bounded by the said direct line from the Wabash to the Post Vincents to the Ohio, by a direct line drawn north from the mouth of the Great Miami to the said territorial line, and by the said territorial line. Eastern state shall be bounded by the last mentioned direct line, the Ohio, Pennsylvania, and the said territorial line, provided, however, and it is further understood and declared that the boundaries of these 3 states shall subject so far be altered that if Congress shall hereafter find it expedient, they shall have authority to form 1 or 2 states in that part of said territory, which has north of an east and west line drawn through the southerly bend or extreme of Lake Michigan. And whenever any of these said states shall have 60,000 free inhabitants therein, such state shall be admitted by its delegates into the Congress of the United States on an equal footing and with original states in all respects whatever, and shall be at liberty to form a permanent constitution and state government, provided the constitution and the government so to be formed shall be republican, can't have a dictatorship, and in conformity to the principles contained in these articles, i.e. the Constitution, and such admission shall be allowed at an earlier period, and when there may be a less number of free inhabitants in that state than 60,000. By the way, so the numbers are 5,000 people in an area. You can apply for territorial status. You get a governor, you get a court, you get a marshal rides heard on the state. 60,000, you can apply for statehood. Most new areas, not all, but most new areas have come into the Union via this process. Arizona, New Mexico, Utah, Montana, the Dakotas, Iowa, Minnesota, Wyoming, Idaho, Washington, Oregon, Oklahoma, Arkansas. Who did I leave out? Anybody? Maine, Missouri, Mississippi, Alabama, Louisiana, okay. The ones that I did leave out include, I may forget one, Texas, which came in as an independent republic and was admitted completely as a state without going through the territorial process. There never was a territory of Texas. It was just the Republic of Texas one day and the state of Texas the next day. 2, California. California was admitted as part of the compromise regarding the Mexican War and did not go through the territorial status, but instead was admitted as a state of California. Hawaii. Hawaii was admitted as a kingdom. It was formerly a kingdom and did not go through territorial process. I'm sorry, did go through territorial process, but was before a kingdom, not a settled territory. And Alaska went through this same territorial process. Puerto Rico is a territory and has been offered on 2 separate occasions the opportunity to vote to become an independent nation, continue as a territory, or become a U.S. state. And 2 times, overwhelmingly, Puerto Ricans have voted to remain a U.S. territory. Other territories include Guam, Wake Island, the U.S. Virgin Islands. Okay. So with a few exceptions, this has been the model by which all states have come into the Union. Very good model. No nation on earth has remotely come close to having such a good settlement and government pattern whereby the new settlers become equals. Article 6, there shall be neither slavery nor involuntary servitude in the said territory. See, no involuntary servitude, so you couldn't sneak slaves in and say, oh, they're my involuntary servants. Otherwise, then, in the punishment of crimes thereof, the parties shall have been duly convicted, provided always that any person escaping into the same from whom labor or service is lawfully claimed in any one of the original states, the fugitive may be lawfully reclaimed and conveyed to the person claiming his or her labor or service as aforesaid. Did you notice something? Labor or service. You escape as a slave. What is that master claiming? He is claiming you owe him service. He is not claiming you are his property. 1787, folks. This is way before Britain ended slavery, way before France ended slavery. Already we're on the process to end slavery in America. Don't let him give you that hogwash. This is a racist nation. BS. Poopy caca. Hydroxychloroquine. We were in the forefront of all nations in the history of this world in getting rid of slavery and setting up mechanisms and governments and processes to do so. And in all the founding documents, we stated that slaves were people. And you know what that meant? That meant sooner or later the courts were going to say, yep, people have the right to life, liberty, and the pursuit of happiness, and you cannot claim people as property. You're done. Finally, be it ordained by the authority aforesaid that the resolutions of 23rd of April, 1784, relative to the subject of this ordinance, be and same are hereby repealed and declared null and void. So the previous ordinance that governed this territory is now over. We're being governed in this territory by the Northwest Ordinance, an astounding document of freedom and brilliance by our founders. So we're going to stop there for today. I will see you guys back here Wednesday. Make sure you grab a copy of Patriot's History of the United States. Get the 15th anniversary edition. You can work with the 10th. Getting back too far is going to leave you behind as we get further ahead here. So just get the 15th anniversary edition. Remember, I'm trying to turn Patriot's History into a video series like The Chosen or Sound of Freedom or John Adams or something like that. Help us out. Go to wildworldofhistory.com and watch the trailer. It's an amazing trailer. Just incredible. Music by Michael W. Smith. You'll love it. And after you love it, buy me a coffee or 5 or 20 or 100. If you want to make great cultural stuff that you can go see at the movie theater, stuff you can watch on your device and say, now I got something to watch tonight that's not junk, that's not pornographic, that's not filled with woke garbage. Help us make this. Okay, I'll see you guys back here Wednesday.